Here's how one of the most famous Broadway musicals of the 1990s still remains a lesson to all creators about copyright law and ownership of joint works. One of you guys asked me about theater cases, and here's one that identified a legal issue that still is not fully resolved. Stay with me because this applies to all copyrighted works, not just musicals. So if you're a songwriter, poet, author, painter, whatever, this all still applies. If you don't know what I'm talking about yet, I'm talking about the musical Rent. This is Jonathan Larson's legacy. Tragically, he died right before its off-Broadway debut, and right before it became a huge success. When he was finalizing the script, he hired a dramaturg named Lynn Thompson. Without going into too many details, they didn't have a formal written agreement identifying who would own what, if anything, they created. After the musical became a huge success, Thompson filed a copyright infringement lawsuit and argued that she was entitled to royalties for the contribution she made to the musical. At trial, it was undisputed that she did actually make recommendations that were incorporated in the musical. That's not in question. The question became, does this make her a joint author? A joint work is a work prepared by two or more authors with the intent that their work be put together to form a unified whole. That sounds simple enough, but courts in the United States are actually pretty unsure about what this means. Some courts take a broad view about this and look at everything from what the creators said themselves to what they actually created and circumstances surrounding that. The court in the Rent lawsuit took a more specific approach that looked exactly at what the word intent means. The court looked at the fact that Larson had told everyone he worked with that this was his musical. He never wavered on that. No matter what anyone did, this was his musical and he was to be the sole author of it. And even though he admittedly liked some of Thompson's additions and even added them to the musical, the intent was that the work be his, not a joint work. But that's not the end of the story. The court also said that there could be an argument that what Thompson created was individually copyrightable. And even though it wasn't a joint work, if her individual contributions were uniquely copyrightable on their own, then maybe a different lawsuit could have been brought under those circumstances. Thompson's lawyers didn't argue that, so they had to refile a new lawsuit, and then that eventually settled. So that open question wasn't decided by the court, and so here's the lesson. Even if you tell everyone you work with that this is your project, that it's your creation, that it's your copyrightable work, that's not the end of the road. It's certainly helpful, but the only way to truly address these arguments of co-authorship coming from people who help you on your projects is to have a written document that outlines exactly who owns what. I know it can be really hard to have these conversations as an artist. You don't want to put a piece of paper in front of someone that you're working with, especially when you're in a creative environment, but if you don't have something in writing and you're working with other creators, you're always going to be dealing with this potential risk of a joint authorship argument or an argument that you're taking someone else's individually copyrighted work and putting it inside of yours. Put your follow-up questions in the comments, and if you're interested to hear more about this kind of law, like, subscribe, and follow along. See you in the next one.